Good afternoon, Proof. My title is China's Fugitive Absentee Trial Procedures, focusing on corruption and bribery offenses. My content is about four parts. First, abstract. Second, introduction. Third, literature review. And fourth, findings and recommendations. First, abstract. Introduction. China's criminal procedure law was amended for the third time in 2018 to add an in absentia trial procedure to the Specific Procedures Part 1, Article 291, Paragraph 1, stipulates that in cases of corruption and bribery offenses, where the criminal suspect or defendant is outside the country, the court may try the case in absentia. This system was established in line with the requirements of the United Nations Convention Against Corruption to combat corruption and is conducive to tackling corruption crimes. Problem statement. However, the trial in absentia procedure still has shortcomings in safeguarding the rights of the accused party. Objective. The purpose of this paper is to analyze the value of China's fugitive type in absentia trial procedure and its problems, and to propose measures to improve China's in absentia trial procedure. Methodology. The paper adopts a qualitative analysis approach using literature analysis, comparative analysis, and normative analysis to analyze data collected from journals and papers. Findings. The study finds loopholes in China's absentia trial procedures, considering to the service of process system and the defense system and the appeal system. Recommendations. To seize the opportunity of the upcoming fourth revision of the criminal procedure law to clarify the criteria for the defendant's knowledge at the time of the service of documents, improve the defense rights of the defendant, and limit the right of appeal of the defendant's close relatives by amending the law. The second, introduction. To close the loophole of not being able to hold fugitives criminally liable, the third revision of the criminal procedure law in 2018 added the trial in absentia procedure. 2022, the Chen Sanchang case was the first and, as of today, the only case in China in which criminal in absentia proceedings have been applied. This case also confirms Tangling's view that a criminal trial in absentia in China is a narrowly defined concept that excludes the absence of the persecution and substantive absence and refers only to the absence of the defense and formal absence. However, although China's criminal in absentia trial procedure embodies the provisions for safeguarding human rights, the provisions are not detailed enough, and there are still loopholes in the provisions for safeguarding human rights. The third part, literature review. First, the value of China's fugitive type in absentia trial program. First, favorable for combating corruption crimes and promoting international judicial assistance. Second, favorable to improving China's criminal procedural system, recovering stolen money aboard, and saving judicial resource. Third, beneficial to make up for the shortcomings of the illegal proceeds. Confiscation procedure. Confiscation procedure. The purpose of analyzing the above literature is to sort out the value of China's criminal fugitive type in absentia trial procedures and to lay the foundation for analyzing the problems and proposing measures in the following article. 2. Problems with China's Fugitive in Absentia Trial Program. 2.1 Deficiencies in the guarantees of the right to a defense. It includes a defendant's right to meet and communicate is not guaranteed. Difficulty in guaranteeing the quality of defense by defenders. Late intervention of compulsory defense. Suspects and defendants do not have the right to choose lawyers for compulsory defense. 2.2 Inadequate safeguards for the right to information of criminal suspects and defendants. 2.3 Inability to prevent abuse of the right to appeal by close family members of the defendant. 2.4 Insufficiently detailed provisions on the time limit for the defendant to appeal. By analyzing the literature of peerless scholars, it can be seen that China's criminal in absentia trial has deficiencies in guaranteeing the defendant's right to defense and right to know, and the next step needs to analyze the measures to improve the defendant's right to defense and right to know. Fourth part, findings and recommendations. First, guaranteeing the right of the accused to a defense. First, guaranteeing the right to meet and communicate with the defense. 2. Registration of defenders to lawyers with more than 3 years of criminal defense experience and the provisions of disciplinary measures for negative defense. Third, advancement of mandatory defense to the pre-trial stage. 4. Grounding defendants the right to choose in compulsory defense. 2. Guaranteeing the right of criminal suspects and defendants to be informed. It is recommended that law be amended to add the following provision. When a foreign authority assisting in the service of process notifies the Chinese judicial authorities that a suspect or defendant has received assignments and a copy of the indictment, it shall be presumed that the defendant has received the assignments and a copy of the indictment. Third, improving China's supervision law and regulations for the implementation of the supervision law. 4. Restrictions on the right to appeal of close family members of the defendant. It is recommended that law be amended to add the provision that if the defendant does not agree to appeal, close relatives may not appeal, has been acted, which not only safeguards the right to appeal of the defendant's close relatives, but also respects the wishes of the defendant himself. 5. Detailed provisions on the time limit for appeals by the defense. It is proposed that an article be added to the in absentia proceedings, stating that the time for appeal by the accused and his or her close relatives shall be 30 days, counting from the date on which the local case handling organ notifies the relevant Chinese judicial organ of its receipt of the judgment. It extends the general appeal period of 10 to 30 days, taking into account that reality of the inconvenience of communication outside the country. This is my personal article. Thanks for listening.